Good evening. We are back with Thursday Thoughts. For those of you who are new to my page, my name is Ajako O. Brown Esquire. I'm the founder of Brown Law, and we are doing Thursday Thoughts. And that's a quick 10-minute live where I answer questions that are posed to me. I usually post them on Wednesday and then come and answer them on Thursday. Before, I was doing them kind of in the afternoon, so I'm trying a new time. I hope that this works better for some live interaction, but either way, we're going to go for it. So today's question is, can I trademark my dance? Okay, so no. I guess that's the short answer. The short answer is no, but the beauty of the law is there's always exceptions, and there's usually a long answer that has both pros and cons. So the question today is, can I trademark my dance? The short answer to that question is no. However, you are able to trademark the name of a dance, and if you are able to successfully protect the name of a dance, then you can prevent others from using that name in any other fashion, right? So one of the reasons why you're not primarily able to trademark a dance is because trademark is used to indicate the source of goods. So we get it, a trademark is basically when I go into the marketplace to buy something, there's a brand name associated with it, and then that gives the customer a sense of whatever it is that they associate with that brand, whether it be quality, timeliness, longevity of the product. So dance wouldn't fall into that category. However, while, like I said, you can trademark the name, and some famous examples of those would be like T-bowing, which you'll see as a registered trademark, or Kaepernicking, which both of those are instances of professional athletes who are, they have signature end zone moves, and they've trademarked the name. But as I was saying, however, you are able to copyright your dance, which can increase your monetary value in the market. So if you're an artist and you choreograph dances, and you have those copyrighted, then you have the right to then license them out to others, prevent others from using it or reproducing it or showing your visualization of your dance in any medium. And so, like I always say, ownership is everything. So whether it comes to anything that you created out of the thoughts of your mind and put into some tangible form, then you want to make sure that not only did it come from you, but that you own it. And with copyright, one of the important things is that you have a copyright. So I guess this is a little confusing, but you have the rights to say, hey, don't use that, this is mine, as soon as you create something in a tangible form when it comes to copyright. However, pursuant to some very recent, maybe in the last 2 years, Supreme Court decisions, you're not going to be able to sue anyone or get damages from anyone for infringing on those rights. So like trampling over those rights for using your work anyway, without a registered copyright. So if you are a choreographer, hey, good to see you, cousin. If you're a registered copyright, if you have a copyright and you register it, then you can get not only damages for someone trampling over your choreographed work by using it or reproducing it or pretending that it's their own. You can get several additional damages, which you can only get if you register immediately. So I would suggest that, and as you're in the process of creating this work, or simultaneously when you're ready to release the work, that you're also applying for your copyright. And so the thing with dance and copyright is there are some rules around it. It needs to be an original work. It needs to be something that you can either annotate or describe with significant detail. So both the composition and arrangement are original and you can describe it. They are specific. If you're a professional dancer or choreographer, then you know about those annotations. But just for short, you have to be able to describe it in detail, and then the composition and arrangement should be original. Ultimately, it's the last part that's a little tricky. Is that it can't be like a line dance or something that is meant for people to copy and do over and over again. So like the waltz or the electric slide, it needs to be something that is intended to be performed by professionals in front of an audience. So those are kind of the regulations around copywriting a dance. If you're looking for more information on that, obviously you can reach out to my firm and we'll be happy to help you. Also, if you kind of just are a researcher and you like to gather information on your own, if you go to copyright.gov and kind of look for Circular 52, it kind of details everything that I've just described, specifically around copyright and dance. So make sure I got all my notes. That about covers it. Again, for those who joined a little late, question today was, can I trademark a dance? Short answer, no. But you are able to trademark the name of a dance, and you are also, most importantly, able to copyright the choreograph that you is a unique and original to you that you've developed. And believe me, it is worth it, because you can command a price for someone to be able to use it. You can prevent others from using it. There's just so many things that owning that right by registering, because you own it when you create it, but that legal ability just to tell someone to stop and take them to court and get money damages if they don't, is significant. So I would urge you to do that. Don't neglect to take all this beautiful work you've created and make sure that you're like legally covered in ownership. And that is it. We're a little under 10 minutes. Next week, I am going to endeavor to explain what an NFT is and how it relates to intellectual property and artists and dancers and musicians, all art forms, and how you could capitalize on it or why you should even care. All right, so thank you so much for giving a listen. I was happy to come and speak to you this evening. I hope that it was helpful, and we will be back next Thursday. Thank you. Bye-bye.